Good morning. Happy Wednesday. Welcome to the Courtroom Files Live. We will start our day once again with Judge Dad.
A few weeks.
Well, I don't know what that means.
If I'm being honest, my mom is in the hospital right now. She can't work. She's pretty much bedridden. My father's not there, and the bank is about to take the house, so I'm kind of concerned with that.
Of course you should be. I'll tell you what. I'm gonna extend your time to pay. I'm gonna let you start to pay this on July the 11th.
July the 11th.
Are you working?
I am.
Where?
I work. It's a company. It's called Gentech. It's my stepfather's friend.
How often do you work?
It's usually 3-4 days a week.
How much do you make?
15 an hour.
All right, maybe you need to get a second job. You start to pay 25 per week starting July the 11th, okay?
Where do I make that payment to? Is there a website or something?
You can go on 33court.com, but there's a fee on that here. Or you can bring it up here.
Okay.
Okay?
Sounds good.
All right, good luck.
Thank you.
If you need more time, come talk to me, okay? On or before your due date. Hunter, Tiffany Ann Hunter, 25 F243648. Your name, ma'am?
Tiffany Hunter.
Okay, what are you asking for here?
Payment arrangement.
Yeah, I understand. Tell me how much you can pay.
If I could do like 20 or 25, a month, every couple weeks.
Do you work?
I do. I'm a single mom of 3 kids.
Where do you work?
At the Meyer gas station, I've been there for 11 years.
I mean, you're kind of asking for a lot. 20, this would take you 10 months.
30.
All right. Okay. 30 per month beginning
I mean,
July.
when I can pay more, I will, the payments will be bigger.
30 per month beginning July 1. If you need more time, you come talk to me. If you don't have the money, just come talk to me. On or
Okay.
before the due date,
Thank
okay?
you so much.
All right, best of
You
luck.
have a great day.
Thank you. Ayesha Abdulwasa Ali. 25-837-166. Your name, ma'am?
Aisha,
Good morning. You're charged with the parental responsibility violation. You have the right to a lawyer. Would you like a lawyer?
No.
So they think that you didn't send your child to school, your child Isa Kataya at 24825 Hall Road in the city of Woodhaven on or about May the 26th to 25 at 1:49 p.m. So they think the child's missing days regularly.
Well.
Hang on.
Okay, sorry.
So that is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
I understand.
Did you sign the advice of rights?
Yes.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
Again, you have the right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea for you. I'm going to give you a personal bond. Here are your bond conditions you have to comply with. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to ensure that your child attends school regularly. The only time the child should be missing school is if the child is ill. You go talk to the prosecutor, see if you can work something out. And this will be the city of Woodhaven prosecutor, so you can go right out in the hallway. He'll bring the file to the prosecutor and then he'll call you in, okay? Good luck, thanks.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Once again, happy Wednesday. Barbara, thank you for the 5. Very much appreciated, as always. Let's go to Florida, and we will say good morning to Judge Wade Mercer. He is doing first appearances.
Ask the court for some kind, maybe a cash bond.
And Mr. Mitchell?
No objection to a cash bond.
All right, Ms. Wilson, what I'm gonna do is let you pick between a conditional release and the cash bond. If you want to accept the release, that's fine. If you prefer a cash bond, that's okay too. This is a first-degree misdemeanor, ma'am. I'm gonna set your cash-only bond at $250 cash. That $250 cash is posted. You'll be released. We're also gonna give you a notice for your court date. Ms. Wilson, when will that be done? Your court date will be June the 30th at 9 a.m. and the jail will give you that notice before you leave the jail. So she has a $250 cash bond and she's got to be back on that June court date. When she posts the bond, she'll be released immediately. She's offered a conditional release, which is like a release under court supervision, but she's chosen the cash bond probably because that has fewer rules to follow than a conditional release does. Does the family have any questions? So the $250 cash will be posted at the jail. When that's posted, she'll be released immediately. Okay. Ms. Wilson, do you have any questions?
No, sir.
All right, ma'am. I wish you the best. We'll see you at your June court date. Thank y'all for coming. We have friends or family here on Rhiannon Santos Peterson. Ms. Santos Peterson, good morning. You're here because you've been accused of one count of violation of the terms of your county probation and a new charge of driving while license suspended or revoked. There is probable cause for the new offense. And Ms. Santos Peterson, what I'm going to do is appoint the public defender's office to represent you, excuse me, for first appearance purposes. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Ms. Peterson. She's going to plea of no contest in 25319 CT to driving license suspended or revoked. Be sentenced to 60 days in county jail, 2 days jail credit. She signed her waiver right to jury trial. She's going to admit that she violated her probation in 23460 CT. She'll be sentenced to 4 months in county jail, run concurrence, and whatever fines remaining on the case.
Thank you. Ms. Santos Peterson, I don't think I told you, but your father's in the courtroom. He's here on your behalf, ma'am. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
And Ms. Santos Peterson, did you hear that agreement?
Yes, sir. Yes, Your Honor.
Do you have any questions about that agreement?
No, Your Honor.
Mr. Goodson, I meant to ask you downstairs and I forgot. This is one of those cases where it appears that she reported for months and just disappeared. But it's also a case where there was a second degree misdemeanor. I just don't know if she can hear you over there. I just want to make sure, because under the old system, y'all would send a letter, and sometimes that would cause confusion if they got a letter saying you're off for probation in one case, but you're still on in the other one. But I think I know y'all stopped that process, but since this is an older warrant, I want to make sure this wasn't one where she was ever sent a letter that could have been interpreted as that she being off probation.
She could have been, Judge. I'll have to go back and look at the file. I apologize, but she was terminated on the driving license suspended.
When?
She got put on probation on June 26th, so she was terminated 6 months, sometime in December. I can call and get the exact date. So she did terminate on that one. She didn't have any conditions on that one. She had no fine. All the conditions that were imposed upon her were on the DUI. She was just put on that probation to run concurrent. So she did terminate on that.
My only concern is if she was back when the probation office used to send a letter.
Yes, sir.
I'd like to know that.
Okay.
Otherwise, I think it's.
Yes, sir.
Mr. McDaniel, are you familiar with what I'm talking about?
Yes, I am. I thought we changed it, it was way before that. I thought but I'm not going to swear to it.
So Ms. Santos Peterson, he's going to check on that. As long as you weren't sent under our old system, when somebody was on probation for a 6-month case and a 12-month case, they got a letter when they finished the 6-month case saying you're off probation, this case number. Well, we found out that was creating some confusion because they're still on probation in the other case number. So we stopped sending that letter. So I think your case was way after that letter was stopped being sent. So I don't think you ever got a letter like that, but if you did, I'd like to know that because that could be relevant. But Mr. Goodson's checking on that now. Ms. Santos Peterson, other than that possibility, if it turns out you were not sent a letter, is this the plea you would like to enter, ma'am?
Yes, sir. I made a mistake and I would like to own up to my mistake. And I should have taken the advice that I was given, and I try to do everything on my own without help from others. And I should have gotten help from others, and I should have listened to the advice. In my youth, I did make mistakes, and I do apologize for that. And I want to do whatever it takes to make it right.
The problem is you made multiple mistakes. You quit reporting on probation, just disappeared. And then yesterday, apparently you were caught driving without a license. So it's not just a mistake. So it's time to grow up. Is this
Yes,
the
sir.
plea you want to enter? Is this what you want to do, Ms. Santos Peterson?
Is there anything else that I could do?
That's your offer today. Mr. McDaniel may work on your case and may get a different resolution. The chances of me putting you back on probation in a case like this is just about zero. In fact, I don't think I've ever done it, but that doesn't mean he can't negotiate a better resolution. Eventually, he may be able to find some things in your favor. If you want to resolve it today, you can. If you want to wait and ask Mr. McDaniel to work on the case a little while and see what happens, that's okay too. He may find out something that explains somewhat why we haven't seen you in over a year since you quit reporting, allegedly. So do you want to resolve it today or do you want to wait?
What would happen if we?
Mr. Goodson, while she's thinking about
He
that.
was terminated, but there's nothing in our file saying there was any, I don't think we sent a termination order out because there's no return receipt, there's no letter or anything. She has
Thank
a
you.
balance on her fine of 448. So she did pay, 60% of her fine.
Okay. I should have asked that downstairs. I'm sorry. I just forgot.
I'm gonna
So,
stick
Ms.
to it.
Santos Peterson, want to resolve it today or do you want to wait, see if Mr. McDaniel can get any different resolution options?
Resolve it today.
Ms. Santos Peterson, I'm going to accept your plea of no contest then to the new charge of driving while license is suspended or revoked knowingly. I'm going to adjudge you guilty of that offense, sentence you to 60 days in jail. You got credit for 2 days you've already served. I'm going to impose court costs and fines of $400. Those will be reduced to a civil judgment. Don't get them worked off at the jail. In the violation of county probation case, I'm going to accept your admission that you violated the terms and conditions of your probation. In that case, I'm going to revoke that probation. And in that case, I'm going to sentence you to the agreed upon sentence, which was 4 months in the Jackson County Jail. You have remaining court costs and fines in that case in the amount of $448. You also have credit in that case. Is it 2 days also, Mr. McDaniel?
Yes, Your Honor.
And the two
Well,
sentences to credit.
They're running concurrent, so she had more jail credit in the other case, but they're running concurrent, so it's gonna be 2 days, it's all-
But the other one's a longer sentence, so it might make a couple days difference.
Yeah.
So do you know how much she has in the other case? It's probably gonna be 4 days, but I don't know.
Yeah.
But it's okay.
4 days credit, Your Honor.
4 days credit, no probation involved in either sentence, and the sentences are running concurrent. That's important, ma'am. That means the sentences are running at the same time. So both sentences are running at the same time. There's no probation involved in this sentence. When you finish this jail sentence, you'll be released. Put this all behind you. Ms. Santos Peterson, do you have any questions, ma'am?
No, Your Honor.
Sir, in the courtroom, do you have any questions?
First offense, 60 days.
The one she got yesterday, the maximum she could be sentenced to was 60 days. So that was her sentence. The DUI is the one she was on probation for. That's the one she got 4 months on, but they're running at the same time. So essentially it's a 4-month sentence minus the 4 days she has credit for.
And with the continue to what?
There was no letter sent in this case.
No, I was going to say, there's no letter because her mail comes to my house.
And so the confusion was when she had 2 cases originally.
Right.
One, she was on probation for 6 months and one she was on probation for a year. She finishes one obviously before she finished the other. So under the old system, the probation officer will send a letter saying you're all probation in case whatever, give the case number. Some people would quit reporting because they would take that letter to say I'm off probation. Well, you're only on probation in one case. So the probation office stopped sending that letter because of the confusion it created. But that letter, that was probably in 2022 or 2023, long before she was on probation. So she was never sent a letter. That was my concern. Any other questions?
So as right now, it's for 60 days and 4 months running together as of right now.
Yep. So total of 4 months, but she has 4 days credit. She very well may do a lot less than that under Florida's game time law, which is the county jails over that. she can get a maximum of 10 days a month gain time. So in a 4-month sentence, you can get a maximum of 10 times 4, which is 40 days off. She could do 40 days less than 4 months if she's the perfect inmate. Any other questions?
Unless she could be put on house arrest and put under my charge, and I can take care of it.
We don't even have house arrests and misdemeanor cases. And the problem is she was gone for over a year. Had she not reported and turned herself in 2 months later without getting a new arrest, totally different resolution. That didn't happen. She stayed gone for over a year. And then when she got caught, she didn't turn herself in. She got caught because she was committing another crime. So she's made a series of bad decisions, but they're minor decisions comparatively. Could be a lot worse. Wish you the best, ma'am. So, Corporal, let's go back to Mr. Friedman's case. Mr. Friedman, I apologize for that delay, but hopefully we've been able to get you an answer on your case.
Your Honor, we don't have that inmate in our facility.
Mr. Friedman, I lost you.
Can you hear me now, sir?
I can hear you, Mr. Friedman, but I have no idea, sir. I don't know. Was he coming from another facility?
Yes, sir. He was picked up in Okeechobee and he's being transported. So I'll just log in tomorrow if that's okay, sir.
Absolutely. You may want to check with the jail before you waste your time. But if he's here is your cutoff 4 a.m., Corporal, or is there a different time?
It's 4 a.m., Your Honor.
So, Mr. Friedman, if he's booked by 4 a.m., he'll go to first appearance tomorrow. If he's booked after 4 a.m., he doesn't go to the following day. But if they transport him today, he should be here long before 4 a.m. Okay?
All right. Thank you, sir. May be excused.
Thank you, sir.
Yes, sir.
Have a good day. Yes,
You
sir.
too.
Mr. McDaniel, we have friends or family here on Mr. Jenkins. Is he still in the room out there? He was the one you were trying to get to go to Chrome?
Yes.
Colin
The
Jenkins?
jail Raymond case, yes.
Jenkins. Back in there.
Number 6.
This is State of Florida versus Colin Jenkins. Mr. Jenkins, you're here in case 25-134MM. That's the one you were on, was it probation? County probation for. And then you also had a new charge in 25245CF. You're here for a possible conditional release in that case. Your mother's in the courtroom, and also Ms. Colbert from the Sheriff's Department's in the courtroom. What is your actual title, Ms. Colbert? Outreach Coordinator with the Sheriff's Department's in the courtroom. Mr. Jenkins, listen to Mr. McDaniel. Mr. McDaniel's been trying to get you in a program. I think if you're wanting to go to a program, but let's see where things stand. Mr. McDaniel?
Your Honor, I spoke to Mr. Collins. He's going to admit that he violated his probation. Understanding he's going to be sentenced to 11 months, 29 days jail. He has 31 days of jail credit today. He's going to be allowed to service the time at Chrome after he's finishes 60 days of jail. And we're just going to ask the court to ask for a conditional release in the felony case so he can go on over there. There's not an information or anything filed in the case yet. Maybe ask the court to go ahead and do the condition. I don't know if I want to go ahead and do the conditional release. If not, they're going to file an information probably within next day or two, I suspect. He's going to have arraignment dates, which is, I guess, not the end of the world.
What are the remaining court costs and fines in the VOP case, Mr. Goodson?
Judge, he had a $370 fine and $408.81. His mother, and I'm not obligating her, she came in last week and was asking about possible paying some of those. I told her that at this point, let's wait and see what happens when he comes to court. So I don't know if anyways, $370 on his fines and $408.81 on the restitution. I know he can work off the fines at the jail, but yes, sir.
And Mr. Mitchell, what's the state's position on the plea agreement and allowing him to serve the sentence at Chrome?
We have no objection on this plea agreement and allowing him to serve the sentence at Chrome.
And is there any objection to a conditional release on the felony once he finishes the 60 days in the county jail? So the probation officer's recommendation was that he not be allowed to go to Chrome immediately because of the extent of what they felt his drug addiction was. That's what it was explained to me.
Gotcha.
And he allegedly came to probation and reported with a controlled substances on his person in his pocket. So that was really unusual.
Give me
So
a second to check something very quick.
yeah, I can't.
So my preference, and I mean, whatever you tell me to do, my preference would be for him as far as the conditional lease is concerned, suggestion is he can go ahead and once he's getting close to finishing his sentence, then you bring him back up to revisit that, and then we'll do the conditional lease. Unless you want to do it now, that's
Well,
fine.
Mr. McDaniel's concern is if an information is filed, does it become the circuit judge's responsibility to deal with it?
Okay.
And if the
we'll do
state's
it.
in agreement,
Yes, sir.
Your Honor,
that's
I
fine.
haven't.
Is that right, Mr. McDaniel?
Correct, twofold, that, and plus I know that they'll have 6 months to file the information if he's not in custody. So if he's got a conditional release, I'm gonna assume when the state looks at it, they're gonna say he's not in custody, you know, and all that changes July 1st, I guess. So I don't know if it really helps or not. You know, so that was my main concern, is that I didn't want him to have to leave the program to come back for an arraignment date. And at least he could stay up there for a few months before, you know, any kind of arraignment date.
That speedy trial rule does change July 1st,
We're
Mr.
double
Mitchell.
checking right now, seeing if Shayla is okay with a conditional release. It's her case right now. She should be here, so give us just a few minutes.
So, Mr. Jenkins, what I'm gonna do is, if you want to go ahead and enter the plea, we're gonna deal with that. And I very well may grant you the conditional release anyway, over the state's objection, but we'll give them a chance to see what their position is. As far as the misdemeanor plea, the admission to the violation of probation and the sentence that your attorney put on the record, do you have any questions about that agreement, Mr. Jenkins?
No, sir.
And Mr. Jenkins, is that the plea you would like to enter, or the admission you would like to enter in the VOCP case?
Sure. Yes, sir.
VOCP is violation of county probation. Mr. Jenkins, I'm going to accept your admission that you violated the terms and conditions of your probation. That was in case number 25-134MM. I'm going to revoke that supervision. I'm going to sentence you to 11 months and 29 days in Jackson County Jail, give you credit for 31 days you've already served. There are remaining court costs and fines of $370 and remaining restitution of $408.81 in that case. The restitution will be a civil judgment. If you don't get it paid, the court costs and fines, you'll get a chance to work off either at the jail or at Chrome. I'm also going to authorize you to serve your sentence at Chrome, inpatient drug treatment facility, the completion of that sentence at Chrome. Once you finish 60 days in the Jackson County Jail, you have 31 days now. So that means 29 days from now, certainly you're free to go to Chrome. That was the same offer he was made at first appearance, ladies, to make sure he's thinking clearly, he's got anything out of his in the system out before he ever goes. You can certainly do the community service while you're at Chrome and take care of all court costs and fines in the misdemeanor case. Mr. McDaniel, I tried to modify the let me ask Ms. Williams, the one that you just printed out, was it in a PDF format? Or was it in a Word format? So the one I was sent, Mr. McDaniel, was a PDF format. So I tried to convert it back to Word to modify it and add the language about the 60 days, and it wouldn't let me. It did some kind of funky font thing, typing over each line.
I would have done that, but I already had the signatures already on it and all, and that's the only problem is all the signatures, so I can't, you know, I figured maybe we just write it in there that, you know, a sentence in on the order if the court's all right with that.
Well, I'd rather you just send me the blank one. I'll modify it. If you send it to me in a Word document, the better practice is let everybody sign it after I do in case there's changes, I guess. But I have no problem with what y'all want to do, but I do want to stick with the original resolution of him spending 60 days in jail. So let's move to the felony case then. Mr. Mitchell, the state have an objection to a conditional release in the felony charge given
No objection from the state.
So I'm going to grant you the conditional release in the felony case, Mr. Jenkins. The conditional release will be specifically with the condition that you attend and successfully complete the Chrome inpatient drug treatment program. So what that means is when that conditional release will be effective, we'll go ahead and get it processed and let Mr. Goodson instruct you, but you actually won't leave until you finish the 60 days. When he finishes the 60 days, he can go to Chrome, stay at Chrome, complete the program. When he gets out of the program, he'll come back to court and see Judge Garcia and myself, and his sentence here will be completed. We still have to deal with that felony charge if the state does, in fact, file charges. Ms. Colbert.
I was just going to suggest make sure that it's known that he successfully complete the inpatient and the aftercare portion of it.
Mr. Jenkins, Chrome has an inpatient portion, which is now 9 months.
Yes, sir.
And they have an aftercare portion, which is how long?
At least 3 months.
At least 3 months. So you understand when I say successfully completed, that means everything, not just the inpatient. So you're only going to be there 9 months, but then you'll have 3 months of follow-up treatment and counseling and so forth.
He'll still live at Chrome.
For that 3 months, he will.
Opportunity to work and basically become self-sufficient.
So you'll get increased freedom, a lot of increased freedom once you complete the 9 months. Ms. Colbert, is that right? So, Mr. Goodson.
So And I apologize, Your Honor. So Mr. McDaniel did an order.
It hasn't been signed.
So
He
my
did
question,
order extended limits of confinement, but it's in a PDF format.
okay, so my
'cause it's already
question
signed.
is a probation revocation. I can place that in the revocation order, or do I just need to do the 11 months, 29 days, and then we're gonna do the order vacate and setting aside? How do you?
You can place the order extended limits confinement.
No, I'm saying
in
that I can put
you
in
can
there that he
place-
can serve his sentence, serve 60 days in the county jail. Upon 60-day sentence, he will report to Chrome and complete that facility. I just didn't need to put that in the probation order if we're gonna do the order, extended limits of
Well, the order
confinement.
extended limits of confinement has the other information that
Yes,
y'all
sir.
need.
Okay, that's fine.
Like what to do if there's a violation. or
Yes,
he
sir.
leaves the
I just won't
program.
put that in the revocation. Thank you.
Thank you. So we're going to go ahead and get the jail to bring you up this morning after first appearance. We're going to ask them to bring you up so you can be instructed on the conditional release. That way we got that out of the way. And then once you finish the 60 days, the next day is, unless it's a weekend, they may not take you on a weekend, but the next working day, he can go to Chrome and go on a weekend for all I care if they'll take him. But the next time they'll take people, you'll go to Chrome and you will actually finish your jail sentence there. And then if there's a court date that comes up between now and then, if the state does charge you and you have an arraignment date, that'll be Judge Garcia's decision on how to deal with that. She'll be notified that you're in inpatient drug treatment, and typically her attitude is the same as mine, which is I don't want to interrupt treatment for an arraignment date if I can help it. Mr. Jenkins, do you have any questions?
No, sir.
Mr. McDaniel, have I missed anything?
I don't think so.
Mr. Mitchell,
Everything's good, Your Honor.
Ms. Colbert, ma'am. All right, Mr. Jenkins, I wish you the best, sir. Mr. McDaniel, I think that takes care of everybody.
Let's hop on the I-75. We'll head north a long way, get up into Washtenaw County, and we'll say good morning to Judge Simpson.
Explains why I was unable to reach you on the phone, sir, for your show cause hearing. So I do apologize for that. Please state your name for the record, sir.
James Johnson. He spent a lot of time there. But that's what I'm off the probation after this. I'm just saying.
Given that Mr. Johnson's in custody and this is a show cause, Your Honor, to ask for an adjournment.
It was just it's yeah, next month. Well, he's being held on something else.
Yes, he might not be released until sometime like that.
Yeah, I got like 30 days, so I'm gone. Another 30 days? Yeah. Like 34. I took a plea to cancel my probation and all that off a violation. So after this, I'll be done with everything. And this is regarding fines and costs and everything.
Yes, Your Honor. It looks like the balance is 674.
All right. Why don't you give me, if he's got 30, then give me 2 months out.
2 months out now would be August 13th.
August 13th. They can't wait for that. I'll adjourn this to August 13th, 2025, 9 a.m. See you then. He's not going to show up. I'm at the eventual. Might as well do that now, right? No. Right?
He'll be here.
I know you. You just don't. Hey, I'm changing, man. Are you? Here. So I'll be here for sure. Make a note of that. All right.
Thank you, sir.
Take care of yourself. Court calls the case People versus William Lamon. Or Layman.
Good morning, still morning. Assistant Public Defender Lauren Perry on behalf of Mr. Lanham. Mr. Lanham, please state your name for the record.
Morning, Your Honor. Mr. William Lanham.
Your Honor, we are here for, I guess, a review date. At our last hearing, which was Mr. Lanham's sentencing hearing, you held the potential 4 days in abeyance for Mr. Lanham to have a serious and frank conversation with his parents, specifically his mother, about the events that have taken place over the last, I guess, year and a half. His parents are here with him again this morning. I did have a conversation with Mr. Lanham yesterday that he did have that conversation with his mother, and that it went very well. I did also speak with him regarding his probation. He says there's been no issues on probation. He's been complying with what he needs to do. So I would ask that I don't know how the court wants to do it. I guess I would ask maybe whole I guess, the full amount is the full amount of time is hanging over his head if he violates his probation. So I would ask that the court just set a regular probation review hearing out a few months.
And Teresa Claire on behalf of probation. Your Honor, probation recommended the additional 4 days because they are statutory with an OWIC.
Yes. How'd the conversation go?
Up and down. Truthful though. Truthful, Your Honor. I was really just at the time I was really just emotional, sad, a bit angry about, the state of the world and things going on per se in-house. Which is not a good thing to be mixing with alcohol at all. And yeah, I was forward about that. I have changed my ways. I've been sober since that date. I have a production company. We've been flourishing. We have a short series going into a film festival next weekend in Oklahoma City. I have a wedding project that I'm working on, a graduation project that I'm working on as well. I'm a very powerful asset to my team in the creativity, as well as working at the restaurant at the Gandy Dancer too. Yeah. Still working with my community as well.
What?
Sorry, still working with my community as well.
So when you sat down and you were honest with Mom, what was her reaction in your mind?
In my eye? She said I can't worry about those type of things. I shouldn't worry about those type of things. But I'm an artist and I absorb things in my environment and that are happening around me. But I just need to channel them in a more responsible way.
And why do you think I did what I did?
First and foremost, out of respect for my mother.
Oh yeah.
To shine a bit of light on me and have me reflect personally about what's going on with me inside, and how that can dramatically affect my environment and the people that I care about on the outside as well.
And sometimes in life, if you're fortunate enough, when you don't have anything else to hang on to, it's going to be that woman that'll be there for you. Right?
Yeah.
And in that respect, you sort of owe her everything in terms of who you are.
Yeah.
Because no matter the reality, I don't know your mom, but I just have to think that no matter what you tell her, no matter what it is, she never stops loving you. Right?
This is true, Your Honor. This is true. And it's a blessing.
Oh, it's a big blessing. Because no matter what people are around you and who's around you, you don't have many like that just really have unconditional love for you. Right? And like I said, I don't know your mom, but I just had a feeling that she's that type of person. She was owed the truth. And you owed it to her.
Definitely, Your Honor.
And at the end of the whole conversation and everything, she didn't say, I don't love you anymore, did she? Did she say that to you?
No, Your Honor. No,
in fact, it was kind of probably the opposite. Right?
Yes, it was.
And I'll tell you something about parents. When a kid, no matter how old you think you are, because you're not that old, but when your kid comes to you and tells you something, you never think that you could love them more. But when they show that confidence in you to come to you and tell you, you love them even more than you did before, if that's possible.
It's eye-opening.
That was part of the reason I did it. The other part of the reason is, how old are you?
32.
Yeah. And you go through all of this stuff, and I guess as they say in the old days, you just thought you were all grown, right? No, go ahead and answer me. You just thought you were all grown.
Not necessarily. Forever a student, Your Honor.
Yeah, I know, but you're also forever her child,
True.
right?
Very true.
And you just thought you didn't have to say anything because I'm grown.
Yeah.
Yeah.
That is. Yes, Your Honor. That is completely true. Didn't want to burden them either.
You know, that's a nice thought, but you burdened her for 32 years. So what's right? Right?
Yeah. I made her laugh though. You know, that did
What?
Good jokes in there. I made her laugh.
Made her laugh?
Yeah, I made her laugh. Good holidays, good birthdays.
See?
Good family events, good family dinners.
Council approach, along with probation.
All right, well, he's muted. For those of you who were here yesterday when we watched Judge Boyd and the closing arguments in that one case in her courtroom, they deliberated for a fairly short time. They asked a question about evidence when the judge said, "You already have it." They asked a short time later, only a couple hours into their deliberation, "We can't agree, now what?" And the judge said, "You've got the law in front of you, keep going." And then a short time after that, they delivered a verdict, and that gentleman was found guilty on all counts. If you have no idea what we're talking about, you can go back to yesterday's live stream and check out those closing arguments. Very polarizing decision. In our members-only show, we talked about it this morning, and we debated it heavily in the chat yesterday, and it seemed like the majority of people probably thought he was either straight not guilty or there wasn't enough proof of his guilt. So was justice done there? Don't know, and we'll never know because we weren't in that room. But it was sus, I suppose. We'll wait out Judge here for a couple of seconds, see if he unmutes himself. If it goes on for an extended amount of time, I may move on, though, so hang tight.
what I'm gonna do is I'm gonna pass this matter. And I may not call it up until the next block, okay? But your counsel will explain why I'm gonna do that. Is that okay?
Thank you, Your Honor.
All right, thank you. Dad, sir, I did not mean to ignore you. All right? No, I really didn't, and I appreciate you being here. I did not mean to ignore you. I'll be honest with you, I like moms better.
Yeah.
All right, but I didn't. Okay, all right. All right, thank you. I'll pass this matter and Miss Perrone will talk to him in a moment.
Thank you.
Thank you.
Well, if I would have known he was just going to pass it, I would have just moved on earlier. But, you never know what's going to happen. Give me just a second. I hit a wrong button. Let me unhit that button. There we go. Let's head to Texas, Jefferson County. We'll see Judge Stevens.
In this court, you were sentenced to 7 years in prison, and that was suspended and probated for 10 years for the third-degree felony of theft. Do you understand what this is charging you with? And this indictment was handed up back in 2021, and it states that you were placed on probation on or about June 3rd, 2021 in Jefferson County, Texas. You committed thefts of a value of over $30,000, but less than $150,000. And it's like dirt bikes. You understand this? All right. We can proceed. Judge counts 1, 3, 9, 10. Let's just, okay, 9. Okay. Was he an absconder?
Yes.
Okay. Well, let's do 1 then. 1. Number 1 states you failed to report to the Jefferson County Probation Office on or about January 31st and May 9th of 2024, which was in violation of your probation order, which required you to regularly report. Is that true?
Yes.
And are you pleading true to that voluntarily, knowingly, intelligently, and because it is true as it is alleged? Do you understand that a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation could be revoked and you could be sentenced from no less than 2 nor more than 7 years in prison. Do you understand? That's the gap we're looking at if you were revoked. So that's what you're facing, that range of punishment that I would be determining. If I follow, so do you understand by pleading true, that's what you're subject to? Knowing that, do you insist on pleading true to this allegation?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Was he an absconder from May
Yes,
of
May.
2024? Okay. How often was Mr. Brumfield to report?
Any alphabet.
No, but how often were you supposed to? Monthly or bi-monthly? Monthly. Okay. And when was he placed into arrest? When did he get arrested?
He got arrested this year in May of this year.
Okay, so he was gone for a year.
Yes.
Oh,
He was in Carrollton and he had another charge and he got arrested
where?
in Carrollton.
Texas, near Dallas?
Denton County, and that was in January of this year, Judge.
Okay. So you've been in custody since January somewhere, but from May of last year to January of this year, you should have been reporting and you didn't. Would that be correct? Okay. 9 states you committed the offense of theft from person on or about January 11th, 2025 in Denton County, Texas, in violation of condition 1 of your probation order, which states you shall not commit a crime while on probation. Is that true? Are you pleading true to number 9, voluntarily, knowingly, intelligently, and because it is true as it is alleged? And again, the same thing. A voluntary and knowingly made plea of true to one or more violations of probation, that's enough to grant the motion to revoke probation. Your probation could be revoked, and you could be sentenced to no less than 2, no more than 7 years in prison. Knowing that, you insist on pleading true. Yes. I find you are pleading true voluntarily and intelligently, and you understand and appreciate the consequences of pleading true. All right, I think that's going to be enough here. Let me just look at one thing. Was there any restitution here?
Yes, sir.
Because it's not in the judgment. It says restitution. There's nothing, restitution payable to, and it says not applicable. What the heck?
The motion reflects an amount of $4,752.50, Judge. That's supposed to be from condition 33.
We paid $1,400.
Well, restitution was ordered by this court in the community supervision order, but it's not reflected in the judgment. Probably what happened is it was to be determined later, probably, and we did the judgment immediately, and then this came after the judgment. I'll bet.
Sure.
But so what's the balance?
The balance right now is $3,312 restitution.
3,312
Yes.
and
50.
and 50. And that's to the complainant in this case?
Oh, yeah.
Yes, sir.
Okay.
Cowboy Schwartz. It's a name I remember.
All right. No agreement. So go ahead, Mr. Dusler.
Well, it's obvious that he had problems in reporting, and he explained to me that he just had trouble getting transportation to do that, but he'll also address the court about it. We've got the new charge up in Denton County that has not been disposed of yet. So whatever happens here, he's still got to take care of his business there.
What were we talking about? A theft of what? What's this?
I don't know the details of it. The ones there, I know it's pending, but he's admitted responsibility for it, and he intends to plead guilty to that. We've still got this restitution owed. He's a young man. He did not have a bad criminal history when we placed him on probation. The good news, I guess, is for a while he did report and he did make payments, and he has paid a significant portion of the restitution. And he's just asking the court to give him an opportunity to hold it in abeyance, let him continue to continue on probation, and maybe he can finish this stuff up correctly. And you'll be able to tell the judge in just a minute. He'll let you talk.
And where's the other crime pending?
Denton County, Judge.
Can anybody tell me anything about that?
I'm looking at a report that reflects that on January 11th of 2025, there's a report that he was involved in stealing from a Domino's delivery driver some pizzas and wings. Whenever they went to arrest him on January 24th, when that subsequent offense arose about him evading. So the theft from a person is from a delivery driver, Judge.
what does the state feel is in the best interest of West District?
Back when he pled originally, I'd offered a cap of 7 years. I felt at that time the 7 years was warranted just because of the nature of his background and all. Your Honor determined that restitution was a good idea, and I feel like I always understand why you move in that direction, Judge. Cowboy Sports was out. The money that we talked about behind his conduct and another individual's conduct coming over from, I can't remember that. I believe they came from a separate location because I don't remember these two defendants being locals. But they came here, they stole these dirt bikes, and they were caught in the process. They damaged that. That's where the restitution comes from. They were actually able to recover the items, but it's the damage that was resulted there. We had a probation offer on the other defendant, and I know that that was a factor as well, that the court determined to do that with Mr. Brumfield. So he was given really a third opportunity whenever he got this probation, because he'd been in trouble before. And even though he was successful for a period of time, he's right back to committing the same kind of criminal conduct. He was an absconder, just failed to report to us for a period of 7 months before he starts committing criminal offenses in another jurisdiction. Now, I know that hasn't been resolved yet, but it sure doesn't look good. And I would recommend that the court not continue this man on probation. That I originally argued for 7 years. I have yet to see anything that warrants any consideration for some time less than that. So I'm going to stand by that.
From probation, anything you would like to?
Originally, when he went on probation, he was sent out to Louisiana. He was a resident of Louisiana, and he stayed out there for a little while. But then he wanted to return back to Dallas, where he said he wanted to live at. But when he got out there, that's when he stopped. And then they didn't actually accept him in Dallas just because he had some other ones in Louisiana that he had to.
Oh, thank you, Mr. Monroe. What do you have to say? If you want to say anything, Mr. Brumfield, this is your time. This is important, a very important point in your life.
Okay, I have the money to finish my probation also right now. And everything,
What do you mean?
Well, right now, yesterday, when I sent my probation officer, Mr. Riley, yesterday, I made my parents a call to Social Security office, and that's.
I don't hear you clearly.
Yesterday, whenever I see Mr. Robert, Mr. Moore, yesterday,
Yeah.
I had made my grandma call the Social Security office and tell the Social Security office how much my balance is right now. And they told me that my balance is for $650. And I said, okay. And the only thing I'm waiting for is to be released so I can get my money and get my card and get my probation also. And whenever I was reporting and everything,
Well, where is the money?
The Social Security office have it.
Okay, here's, you're not going to get released to go get it. That's not the way it happens, because we had experience like that before. Trusting people, they leave, they never come back. We have to go find them again. And then when they're caught, it could be a while. But you're not going to get released until this was resolved. But I want the money's paid. That would help you. But you're not going to get out to do that. You're going to have somebody on your behalf do it, if that's what you really want to do, which I'll give you the opportunity to do that. But you're not going to get released. You're going to have to work through somebody else, family, or somebody you can trust to get that. And you get it, and you get that resolved. I'm not going to just let you lollygag around on it. I mean, you just have days, not weeks, days to figure that out. But I want to certainly the restitution to victims. That makes a difference to me. That's one way to fix it. Plus, it benefits you in sentencing. I reward people who can do that. even at this stage. But you're not going to get released to do it because we have a bad experience with that. And we're not going to go try to chase somebody again that, well, not that you do it, but it's happened before. So somebody's ruined it for everybody else. So that's not what we learned a lesson. If you can get this restitution, I can give you 1 week. 1 week. If you can do it, get it done, get it over to probation. We'll come back, pick this hearing up over here, pick the hearing up where we've left off. And you and anyone else like this who pay the restitution back, the court rewards them. But it's still, you're going to pay it. You're going to pay the consequences here, but you can minimize it to some degree by paying the people back. Are you going to be able to do that?
Yes, sir. The only way I can pay my probation with you, unless I have to go to in front of the Social Security office.
I'm talking about the restitution.
Yes, sir. I have to go in front of Social Security because they don't want nobody else but me because my grandma tried to go up there and instead of saying that they want me to go in front of them so I can.
Well, I'm not going to let you. I'm not going. I can't release you for that. If you took off, it happened again. Y'all got to figure it out somehow.
I don't think he's gonna be able to access those funds. They're gonna make him do it in person. And I'm not even aware funds exist, to be honest with you, just based on what he's saying.
Yeah. Well, you're not gonna get released for it. You got to figure it out. If you can do it, I'll give you a week to try to get it done. Maybe your family can get the money together. And then when you're able to, you can go give them back that money when you are released sometime in the future. But no, you're not going to be able to amble about to make business arrangements and take care of business needs like this. Not when you've got an evading arrest. You've worn that freedom out while you're on my probation. But you think they might be able to help you in a week, your family?
No, sir, because they won't, because the Social Security, because whenever I went home in 2022, I had to go in front of the Social Security so I get my full $28,000. I had to go in front of them.
Judge is asking you if your family, your mother and grandmother have the money otherwise. Could they get the money to pay your restitution and then you get out and get it from Social Security? Would they have the ability to come up with that kind of money?
The only thing they can try to come up with is my funds so I can go home and try to get my money back. That's the only thing they can try to do so I get my money back.
No, I don't think it's gonna happen, realistically.
Okay. Yeah, let's
You can reset it, I think we're kicking the can down the road, to be honest.
Yeah, what we're not calculating into this conversation is the fact that Denton County has a hold on them too, Judge.
Yeah, you wouldn't be able to get out anyway. He says they've got a hold. You wouldn't know. You wouldn't know that. He would.
He's got to resolve those, otherwise they're not going to just let him, like you say, amble around them.
Yeah, go ahead.
Oh, I don't have it hold because.
All right. No, it's not a debate.
No.
They know.
I know.
They know there's they have information that says there's a hold from Denton County. And as long as that is, and he's good for his word, they know that, then they alert the authorities. Now, they may release that hold, but right now, he says, and he's good for his word, there's a hold on him out of that, on you out of that Denton County. Which is a problem for you. You got to take care of that one way or the other after this. But once again, if there's a way you can get it paid through your family, the court would reward you. But if that's not something that's realistic, we got to move forward today. And I can always, if the court sentences you to confinement, then I can always change that judgment within 30 days if something happens. I can bring you back and I can change it and or whatever you might be able to get done on your behalf. But you're going to be in custody if I sentence you. You're going to be in custody for the next 30 days.
I think that's appropriate. Go ahead and do that, and then we've got you set 30 days to try to.
On people on his behalf.
Yeah.
It's, I know you're talking about Social Security, but I think I can't speak for him. And but I know sometimes government agencies can be hard to deal with, but it's also been my experience that people over believe that too. Quite often the government authorities work with people a lot easier than they thought, or people on their behalf if people on their behalf or close relatives who have proof and information of what they're doing and why they're doing, and it's in the best interest of justice, and they seem to work together when that can happen, but not always. Nothing further. I'm going to find there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1 and 9 have been proven true. And did the state want to add anything else?
No, Your Honor, I've made my best argument.
And you're asking for
7 years.
And Mr. Duser is asking to continue you on probation in some way. Again, there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1 and 9 of the first amended probation have been proven true, as you have pleaded true to those voluntarily, knowingly, intelligently, and appreciating and understanding the consequences of pleading true. Your probation is hereby revoked. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 6 years. And restitution is ordered in the amount of $3,312.50 to the complainant in the indictment in this case. That will be placed in this judgment. And that's the finding of this court. If something can be done on restitution within 30 days, let me know. And we'll see what we can do about rewarding you somehow. Anything else? That is all. Thank you. Next is Mr.
Ashley, thank you for gifting a membership. Very kind of you. Swamp Fox, you are the recipient. Congratulations, you are now a certifiable law junkie, and you have access to the pre-show every morning, a half an hour before this live. Let's do this. Let's stay in the South, but let's go over to Louisiana, the Board of Pardons and Parole. They are doing parole hearings. Let's see if we have a winner or not.
2025. My name is Cheryl Renatza, serving as chair today. My colleagues on the panel, to my left is Mr. Danny Byrod, to my right is Mrs. Stapleton. Our remote location at this time is at Allen Correctional Center. With the staff at Allen, please introduce yourself for the record.
Good morning. I'm Deputy Warden Brent Thompson. Good morning, Assistant Warden Crystal Simon.
Good morning, Jessica Manual Classifications. All right, thank you for accommodating us this morning. And we have Mr. Howard there in front of us. Mr. Howard, would you introduce yourself? Tell us your name and DOC number, please.
My name is Kentrell Howard, DOC number 448-329.
Right. Yes, sir, Mr. Howard. Let me acknowledge the folks who have joined us here in Baton Rouge that are here in support of your parole request. We have family members, Lakeisha Stafford, Ophelia Howard, Kentronika Francis, Sharon DeVille, Keandre Stafford, and Kalasia Stafford. And also in support is Jerome Boykin. Mr. Boykin and Kalasia will be speaking on your behalf, and we'll ask them for their remarks shortly. First, let me just read some identifying information into the record, and then we want to hear your statement. So, Mr. Howard, you're classified as a third felony offender. You're currently serving a 30-year sentence, sentenced in Terrebonne Parish in 2017. Possession with intent to distribute cocaine as a habitual offender. Your parole eligibility, has passed. It was July 24th, 2023. You have a good time date, which is January 30th, 2045. Is all that information correct, sir?
Yes, ma'am.
So I see that where this is a rehearing, you had a parole hearing in the past. So we do it a little different now. We want to hear your statement first. We want you to tell us why are you in jail and why do you think we should vote favorably for you today?
Yes, ma'am. Well, I feel the parole board should grant me parole because I suffered and I learned my lesson over these 9.5 years. And I've been doing what I was supposed to do in prison, trying to, better myself. And I've been doing it. And I understand the people that I hurt selling drugs. I hurt people and their family. And I also hurt myself and my family who had DOC headquarters. And I just want to apologize for my foolish actions.
All right. Well, let's ask Warden Thompson, what can you tell us about Mr. Howard?
Howard and I spoke on yesterday. I can say he's doing well as far as his disciplinary is concerned. He hadn't had a write-up in approximately 3 years. And that's pretty good. But I also told him on yesterday that I encourage him to get finished with his GED. That's something that he really actually gonna need to help him when he gets to society, that he won't repeat actually coming back into the system. And I also told him on yesterday too, I think something that's gonna help him out a lot. We have a program here called the Voice of Men program, which is a 6-tier class that these guys will actually take upon completion. I think that'd be something very, very essential for him to have and get completed, so it can help him actually stay out in society if he actually do make it to parole board here in the near future.
How long is that program?
It's 6 months. It's 6 months. Yes, it's 6 tiers per month. But it's a very, very effective program. You have a lot of inmates on the backlog that's want to get involved in it, but it's very, very, very good for these inmates. A lot of them like it and have some good classes that's being taught in there as far as recidivism, male and female relationships. But I think that'd be something good for him.
All right, good. Thank you. Thank you, sir. All right, we'll hear from the folks who want to speak on behalf of Mr. Howard. First, we'd like to hear from his daughter, Kalasia. If you'd step up to the podium, please.
Hi, I'm Kalasia. The last time I see my father was when I was 11. So I've been out here and trying to build upon resilience over It's been a great job. We spent 9 years. This is really hard to live upon. I'm so proud of him. With things that he talked to me about the things that he wants to be, and I know he would invite to. All the things, the plans, the things that he told me to research for him to better himself. All of the times he would call me back to back to back so we could complete our conversation. He wants to know about this program. Is there anything that he could bring to y'all attention that he can try, to come home? And he's a completely different man. Before he was incarcerated, our bond, it wasn't that strong. But to call every day, constantly, all day, and we sit there and get to actually know him through a jail phone, that means everything. And I know for a fact, I believe he's gonna come home and he's gonna do it.
Thank you. All right, and, Jerome Boykin, please. Morning.
Name is Jerome Boyd, retired captain with the Middleton Sheriff's Office. I'm also president of the local NAACP at Moments. I'm here today in support of this power being paroled for several reasons. One reason is I know he have changed. And the reason why I know he have changed because I spoke to him by phone. When he first went to prison, up until now, him and I have been conversating. I've noticed the change when he first went there, and after he changed, I know he have changed. He's been incarcerated for almost 10 years. And if you look at his record, then he have a few minor infractions, probably less than 7 or 8 in almost 10 years. I don't feel that Mr. Howard is a threat to society. Although I don't condone drugs, using drugs or selling drugs. But however, I think he have done his time. He has proved that he can live in society. And I think he is a better person now that he has spent almost 10 years in prison. I own a company, JB Sweeping Service. It won't be a problem for him finding employment. Also a consultant for Senator Mike Fazek, who owns PCM. It's a pipeline company. It won't be a problem finding there. So this option for employment is probably better than most. Probably have 3 or 4 options of getting a job once he is released from prison. I know he was tried as a habitual offender, so I went back in the record to try to see when it came to the drugs. And I think all of the charges that he had, it was probably less than $1,500 for the drugs. So this is not someone who has been he was a user and a seller. But I think he earned the right to be released back in society. I have approximately 10 to 12 inmates, some were committed murder that I have been working with since they have been released from prison. And so far, I can honestly say to you all, no one has been arrested or put back in jail or prison. And I'm asking you to send him back so I can work with him. Thank you.
Sure. And Shamika Smith, please.
Morning, our cousin, through this whole time in Costa Rica, we have been talking. I see a change. I know he's changed. He's ready to come home to his family. We're here to support him, willing to pay his parole fees up to 6 to 9 months of his fees. When he come home, we have an extra vehicle that he can use to get back and forth to work while he's out there trying to get himself together. And I'm just saying that I know he's a changed man, and I think he needs to come home to his family. Thank you.
Thank you. All right, Mr. Howard, your case was assigned to Mrs. Stapleton. Would you answer her questions? Good morning, Mr. Howard.
Morning.
What in your words
do you find, I know what you were arrested for. I know that, that you ran in the house that you ran into, they found a gun in it. Am I correct?
That was a case that I was never convicted of the particular charge. It was the charge with me and Laura Durkin that got stopped. That's where they found drugs at.
Uh-huh. And did you run?
Yes, ma'am.
Did you run to a house?
No, I was found I was picked when I was arrested. I was arrested at a house, but I had warrants for a drug charge.
Right. And when I read this report, it says when they went into the house, there was a Glock Model 22 and a 40 caliber handgun that was retrieved in the house. And a bag of suspected crack cocaine in the door handle of the vehicle that you were driving. You were later charged with the simple criminal damage to property of over $500. So,
yes, ma'am.
Did you know anything about the gun in the house? Two guns.
I knew the house. I didn't live at the house. I never seen the gun, but
You
the
just
drugs
ran out the person.
Is a girl that I knew.
Hmm.
They had the gun in the house, but the drugs that was in the car, I know about the drugs.
Okay.
Drugs.
I noticed that on the last hearing in 23, they had suggested that you take certain classes. And what I did notice is that you've taken those classes. Tell me all the classes that you've taken, sir.
I have taken Thank You for a Change. I have taken Victim Impact. I have taken Living in Balance Phase 1 and 2.
Yeah.
Since my last hearing, when I went to my last hearing, I had no subjects completed for my GED, but now I have 4 subjects. I just have 1 subject left and I will have my GED.
Okay.
And if your parole board was to grant me parole, I was wondering, could I get a special condition to take this last subject? I just have 1 subject left.
Okay.
And I have Man in the Mirror. I have 2 NAAs. I got a lot of certificates I can't remember.
Yeah, I'm seeing all of that. And that's very commendable. What they told you to do, you got busy with it. I noticed that your disciplinary reports, I only see 2 here. Is that correct?
Yes, ma'am.
Yeah, so that's, like they said, that's not a problem either. And then, of course, I see that you successfully participated in the substance abuse program. So
Yes,
that's another one that was very important. It says you're eligible for the transitional work program. Do you work outside of the jail, prison?
No, ma'am.
No, okay. The warden was talking about an interesting class. What do you think about that?
From my last hearing,
Uh-huh.
I had to vote, and I was granted by two parole members, Ms. Pearl Wise and Mr. Andy Marbella, and I was denied by Mr. Pete Freeman. Mr. Pete Freeman recommended that I needed living in balance and victim impact. And I never knew anything about the other classes.
Okay. Yeah, I see where you accomplished everything they asked you to accomplish. You got a 30-year sentence, and of that, you've just a little bit short of serving 1/3 of a 30-year sentence. And I'm kind of concerned about that. You have opposition from the DA and the sheriff's office. That's the opposition. Anybody else have questions?
Yeah, you've had 4 periods of supervision already, and 3 of them got revoked out of them 4. What would be different this time? What have you learned? Why would it be different, 4 is a chunk, 3 out. Yeah, that's what I'm trying to figure out. That's my problem with it.
I was a little younger back then. Now I mature. My prior convictions, I was always getting slaps on the wrist, and I never served a long time in jail. And this time, I got a 30-year sentence. I've been incarcerated going on 10 years, and I definitely learned my lesson. And I'm just waiting on the time to prove myself to the parole board, my family, Mr. Jerome Boykin, and people in society that I'm a changed man.
That's the only question.
So let me ask you this. Your daughter mentioned that she was excited about your plans. What are your plans?
I plan to get out here and work instead of going back to the old life and be there with my family. Because I have 5 kids. I have three baby mothers. Before I got incarcerated, my children, they weren't familiar with each other. But since I've been in here, all of them, they together now, and I'm the only one that's missing.
That's pretty good incentive.
I just waiting on the opportunity to prove myself.
So we talked about, you told Ms. Stapleton about all the programs you took. What was the one that you got the most out of and why?
Thank you for a change. Thank you for a change. Because before I react to things, I think about it. I don't let my reactions override my thinking. And that's how I stayed out of trouble all this time in jail. I have 2 write-ups, and if I feel if I didn't take that class, I probably would have more, because I ran into many situations where I backed down from fights because I didn't want to get into trouble.
Well, you are to be commended for your disciplinary record. You're right. It's 2 write-ups and they were both within about 3 months of each other in 2022. And you've done really well since then. So you're to be commended for that. I don't have any other questions. Are you ready to vote?
I wanted to ask also, you were talking about with Ms. Renata about your plans, and I heard Mr. Boykin talking about you coming to work for him. Have y'all discussed that? I know you discussed it with us now. Have y'all discussed it?
Yes, ma'am.
Is that something you're interested in doing?
I asked him.
You asked him?
I asked him. And
Yes.
Over the years, I looked up to Mr. Jerome because he's a positive person. And
yes.
I bothered him a lot, called him a lot, and he was gonna give me a job. I had 1 subject for my GED.
What's that subject?
Language.
Language. Okay.
I'll go to executive session.
We have a motion by Mrs. Stapleton for executive session.
Second.
Second by Mr. Byron.
Renata.
Yes.
Stapleton.
Yes.
Byron.
Okay. All right, we'll be in executive session for just a moment to discuss confidential matters. Stand by.
Okay, well, they're having their discussion. Lindsay, thank you so much donating 5 memberships. Very, very kind of you. Congratulations to all who were able to nab those. You now have access to a bunch of fun things, but in my opinion, the biggest thing that you have access to is the pre-show. That's a half an hour before this live. You'll see notifications for it. Just make sure you have your notifications turned on, and feel free to join us there, where I let down my hair, at least the 5 that I have left, and we talk about a whole bunch of things. This morning we talked a lot about the Judge Boyd case yesterday that resulted in an interesting verdict. I continue to maintain, and yeah, I'm sure I'm biased because this is my channel, but I think this is one of the best communities in the LawTube space right now. It isn't the biggest. We'll get there someday, but I think it's the best as far as the quality of the people. So thank all of you. You're not only kind to us, you're kind to each other, and that's rare to find spaces like that. Most of these spaces are just buried in drama, and this isn't one of those, and it makes it very enjoyable to come back here every single day and interact with you guys, so I appreciate it. But speaking of community, if you're watching right now on the YouTube app, if you go to the channel page, you'll see a new button, and that new button says Visit Community. This is a new feature within YouTube. It's still technically in a beta test. It's generally only been handed out to very large channels, but I have been lobbying my contact at YouTube for a couple of months now to get in on this, and it got granted yesterday. If you click on that Visit Community button, not only will you see my posts, like the quizzes that I've been posting and stuff every day, but you now have the ability to post as well. So use it. It's kind of like a Facebook type of space, if you will, or a Reddit or a Discord or whatever you want to call it, but right within this particular community on YouTube. So we can all interact there. You can post links and pictures from different courtroom things that you find that you think we might be interested in. You can post pictures of your animals if you want, thoughts that are on your mind. I don't care. The only thing I ask is that you keep it clean. We will, of course, monitor it and boot posts that are not appropriate. So the only thing I ask is that you keep it appropriate. But use it, please. I had to lobby really hard for that feature. So, and I'm sure they probably gave it to me because they were sick of seeing my emails day after day asking and begging and reminding them that I put in this request. So it's probably why I got it. So I think they're going to be a little bit, so I'm going to monitor it. We'll come back to it. In the meantime, let's go back to Judge Stevens.
Director,
Yes, sir.
coming in town.
Yes, sir.
Well, we're gonna, it's Jerry, but we're gonna welcome Peggy.
Oh. Tom.
Okay, Pat Calhoun?
Yes,
Is that you, sir? And we call, cause number 20-34315, the state of Texas versus Chad Allen Calhoun, here with Mr. Dusler, your attorney on the state's attorney. There's a motion to revoke unadjudicated probation that is on file as of April 3rd, 2025. Are we going to proceed on that?
Yes, sir.
And Mr. Calhoun, raise your right hand. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer. In summary, sir, this motion alleges that on December 16th, 2021, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is all of that true?
So, count one, two, whichever one.
One states you provided a urine sample on or about February 25th, 2025, which showed the presence of methamphetamines and amphetamine in your system. And that was in violation of number 10 of your probation order, which is do not use or possess any drug.
Yes, sir.
And is that allegation true and correct as it is alleged?
It is very so.
Are you pleading true and correct voluntarily?
Yes,
And
sir.
because it is true.
Yes, sir.
Do you understand that a plea of true to one or more violations of probation, a voluntary and knowingly made plea, that's enough to grant the motion to revoke probation. Your probation can be revoked. You can now be found guilty, and you can be sentenced up to 2 years in the state jail. Knowing that, do you insist on pleading true?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir. Very much.
Okay. Let's see. A bit more on this, sir. An agreement has been reached here where you would be revoked, found guilty, sentenced to 1 year in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked here, States Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney or the
Yes, sir, I
competent
did.
reviewing court? States Exhibit 1 tendered into evidence without objection admitted. This states that all the parties, including you, understand that if I follow this agreement, you have no right of appeal. I'm going to do that. Let me ask one other thing. This is something I've noticed here. I guess it's under the order that states reimbursement fees. Those are probation fees. Is that
Yes.
what that is? That's what I've never noticed it before. Reimbursement fees. That's not restitution.
No, sir.
No.
Okay. In the order, in the deferral.
Can you show me? I saw it.
It's entitled reimbursement fee / supervision fee, Judge.
Okay. I'm not familiar with it on the judgment, maybe if I saw the probation.
But it's not restitution.
No, sir. There is no restitution on this.
I'm going to follow this agreement. If nothing further, I'm going to find, sir, you are pleading true voluntarily to a violation of your probation. You are doing that. You understand and appreciate the consequences of pleading true. That is enough to grant this motion to revoke probation. Your probation can now be revoked. I hereby revoke your unadjudicated or deferred probation that you have been on. And this motion is granted. Earlier in this case, you pleaded guilty voluntarily to the state jail felony burglary of a building. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony of burglary of a building. I am following this agreement. You are hereby sentenced to confinement in the state jail for 1 year. You will be given credit, of course, for all time you have served in accordance with that charge.
Yes, sir.
Do you understand what has happened today?
Yes, sir. I do.
Judge, before you pass that aside, I've double checked. There is a restitution amount on this. It is $5,000, and I know you are on that. What your typical rulings are, and I wanted to clarify my mistake.
Okay, maybe that was something, I don't know. But here in the probation order, there is restitution is owed the states in the amount of $5,000. Was anything paid on that?
He paid $572 on.
572?
Yes, sir.
So it's 572 less of.
His balance is $4,427.
4428.
On restitution.
All right, restitution is hereby ordered in the amount of $4,428. That will go to the complainant in the indictment, Rodney Gravett. Do you understand what has happened today,
That
sir?
part I would like you to explain, please, sir.
Huh?
That part I could use a little and I'd like to know what that means, sir, please.
That means that you still owe $4,428.
Yes.
It's in the judgment.
He would have to.
And
it won't cost you any more time in jail. Yes, sir. Thank you.
But it will cost you the money.
Yes, sir.
Yeah, they can. Somebody can file a civil suit now against you, and that would be and if they get the judgment, which is normally just pro forma, it shows up on things that when you try to purchase a home or get credit, that can be used against you. But also, it was determined that was the loss, and you're getting a deal out of this. At the end of the day, that's half of what you could get. And it's, at the end of the day, it's up to you, but the right thing to do is to pay people back.
Yes, sir. Very much so.
That's the right thing. And maybe maybe your conscience bothers you, like I hope most people, and you'll do something about it and fix that.
Yes, sir.
that would be the right thing to do all of those, but that's your soul,
Yes, sir.
not mine. Also, anything else?
No, sir.
That is all. Thank you.
Need your right thumb,
Yep,
sir.
we need your right thumb. Theodore Follow is going to be next.
All right, let's go back to the Louisiana Parole Board and see how this came out.
Is there any objection? No. Hearing none, we'll go back in regular session, Mr. Howard, and we are prepared to vote. Mrs. Stapleton will be voting first.
Mr. Howard, today I'm going to vote to grant with conditions that you complete the Boys to Men program and your GED.
Mr. Barra.
I'm also going to vote to grant with the special condition that you have a curfew of 10 p.m. to 6 a.m. for the first year of supervision, unless you have a job that requires you to work during those hours, and that you also complete outpatient substance abuse following up on whatever is recommended from the programs that you'll be attending before that. So in other words, follow all recommendations from any substance use providers that you're involved with.
All right, Mr. Howard, you were asked to do some programs at your last hearing. You completed that. You've got a good conduct record. The warden spoke highly of your record and has made some really good recommendations. So my vote today also is to grant, but after you complete that Boys to Men program, still working on your GED. Now we want you to get your GED. If you're not able to obtain that before you finish the Boys to Men, you still work on it when you get out. You got to get it. And then the curfew and the substance abuse follow-up that Mr. Byron mentioned. Do you understand all that?
Yes, ma'am.
You got a little more work to do, but you're on the right track. Good luck to you, sir.
And don't forget, you got 20 years if you mess up any of those special conditions. So you still got a lot of time hanging over your head as an incentive, and no gun, and not around anybody who handles guns. You get caught with a guy with a gun, it's just as bad as if you got caught with the gun yourself.
Yes, sir. I have one question.
You might have to change a couple of people, places, and things that you were used to.
Yes, sir.
What's your question?
I have one question, like, I taking the last subjects, I'm not real good with school. I failed like a couple times trying to get these subjects. So you basically telling me like if I don't been to pass the test by the time I finish Boys to Men, I could take it in society.
Still work on it outside.
Yes, ma'am.
All right? And you got a lot of people in this room that'll help you with that language that you need. So
I will.
good luck to you. All right.
Thank you.
Okay, Michael, first off, you were betting that it wouldn't be granted, so you lost all your money. But you gained our respect for your Boys to Men reference, because the same thing was running through my head too. So good on you. That was good to see. You know, I know that not all of you like it when I go to Louisiana for the pardon and paroles, but I watch them for a reason and I show them for a reason. Number one, it's a different kind of court and law situation that we don't otherwise see. And the other reason is every now and then we get a good surprise like this one, and we need moments that aren't just somebody's misery. So it's good. Let's go back up to Michigan, and we'll visit with Judge Dad some more.
Intact. That's what happens.
I showed him what I'm going through because of it, and I told him he's gotta be stronger.
No, he's going to go to school, or he's going to be in his room for days and days and days. I mean, that's just the way it is. No video, no TV, no radio, no nothing.
Nothing. He doesn't have that. All he has is TV. I took all that away from him here. So it's not like he's staying up all night on phone or on electronic. He really isn't.
Okay, you want to plead to this?
Yes.
In violation of Woodhaven Code Section 96-50, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the original charge pursuant to stipulation. $250 is your total. You can go down the hall and pay that. Keep that child in school. Good luck. Thank you.
Bradley Jacob Malott, 25W838481. Your name?
Bradley Malott.
Yep, charges retail fraud. You want a lawyer?
Yeah, I would.
Okay, we'll go get you a lawyer. Okay?
Thank you.
Tangeray Danielle Allen, 22W831729.
Michael A. Carmen, P73824 on behalf of the defendant, Your Honor.
Name? You're muted. Name?
Tangeray Allen.
All right, this is retail fraud charge. What's going to happen here? What is she doing? Mr. Carmen?
Amute, waive the formal reading, Your Honor.
Okay, I'll enter an act.
Amute, waive the formal reading.
I'll enter an act guilty plea. Where's she been?
I've been incarcerated since December 29th of 22. I'm in Michigan Department of Corrections. My lawyer informed me that a hearing paper was sent to my address, but I've been incarcerated since December of 2022.
Okay. How long are you going to be in the Department of Corrections facility there?
My release date is December 5th of 2025.
I don't mind giving her credit for time served if we can get proof of that. Is there a way we can get proof of that?
I think if you run my name, I've been it shows up.
Hang on. Lisa, what did you say?
I can look it up.
So for purposes of arraignment, she stands mute and waives formal reading, right?
Yes, sir.
So I'm entering a not guilty plea. We're going to run that. If that's true, I don't mind just giving you credit for time served. If that's what you guys want to do, you don't have to do that.
Okay. Well, I didn't make it to prison until April of 23, but I was in Oakland County is where I was sent from. I was extradited from Toledo, Ohio, and I was sent to Oakland County. And because I'm from Toledo, Ohio, so I was extradited from Ohio to Oakland County, and then from Oakland County, I came to prison April 26th.
Miss Allen, do you have a hyphenated name?
Yes, Carter Allen.
Okay, let me check that way.
If not, I can adjourn this and she can get proof of incarceration.
It's just going to take me a minute. They have her listed as a different name in here.
Why don't we just do that, counsel?
Can we just hold on a second? Because then I have to do a writ to get her back out.
Yeah.
Just give me a minute.
Well, let me see here. Why don't I pass that case, let her look, and I'll go on to this next one, okay? Stay right there, ma'am. Just don't say anything. I'm gonna go on to another case. Jessica Rose Schaff, 25W838765, A, B, and C. And then I also have 24F242987. All right, your name, ma'am?
Jessica Shaw. Good morning, Judge. Madison Gable from Madison Shaw.
All right, so she's charged with OWI, suspend, and no proof of insurance. Does she stand mute, waive formal reading?
Yes.
On both misdemeanors? Yes. Also, I'm entering a not guilty plea. I'm entering a plea of denial on the C file. And then I'm also going to, I'll adjourn 24F242987 unless you can pay that today. Can she pay that today?
Are you able to pay that today? Judge, is there any way we can, court can waive any penalties or late fees?
Why?
The amount?
Why though? Why wasn't she here?
She had moved at that point and she didn't receive the notice.
Yeah, more people moving. When did you move?
Almost 2 months ago.
Well, he wrote you the ticket May 17th.
Oh, I was talking about the one dated November, Judge. I apologize. There should be another one.
Well, it doesn't matter. What's, I don't understand. This one's from November of 24.
Yes, Judge. That was the one I was actually asking the court. She's gonna plead to that one. I was asking the court just to see if they would waive any penalties or.
So she's gonna plead to this today?
She's gonna plead to the 2024, the
Failure to pay.
Correct. The other ones, if you
I
kind of
know.
wrote it up.
Well, let's slow it down. Let's just slow it down.
Okay.
We're gonna adjourn the other ones for discovery, but is that what you wanna do, is plead guilty to this no proof of insurance?
Yes.
If you plead guilty here, you could get 1 day for every $10 owed. You could get 28 days. Do you understand that?
Yes.
And you have the right to a hearing. If you plead responsible or guilty to failure to pay, then you could be held in contempt and jailed 1 day, so you could get 29 days. If you pay it in part, you can satisfy this in full by payment, in full by serving the jail term, or in part by payment and in part by serving the jail term. As an example, if you paid $82, you just listen. If you paid $82, you'd still owe $200. You could be held in contempt and have to serve 20 days on that. Do you understand that? Nice and loud for me.
Yes, Your Honor.
All right. Okay, to the charge then, that you failed to pay, 282, how do you plead?
Guilty.
Failed to pay that?
Not the full amount.
Did you fail?
Did you fail?
Yes, I failed.
Anybody force you to plead guilty?
No,
Why didn't you pay this?
I don't really have an excuse for you. I was moving.
Where does she work?
Yes, Judge. She's a nurse.
You're a nurse? Where?
I lost my license.
Her license.
Well, it's suspended.
It's pending the outcome of the white charge.
How much do you have today to pay this no proof?
$100 I can pay for that.
You pay 100 now, when can you pay the rest?
What's the remainder on?
Well, you owe 282 plus your clearance fee. Your license is in suspension because of failure to pay on this, and you have to pay a clearance fee of $45 on top of fines and costs to get that suspension lifted.
Say a month. Maybe 2, if possible.
All right. I'm accepting your plea, as I said. You pay $100 now. You pay $115 more by July the 18th. I'll waive the balance, but you still must pay the clearance fee, okay? So I'll save you some money here, but you're gonna have to essentially pay $160 to pay the case off, after you pay your 100 today, to pay the case off and get your clearance, okay?
Okay, thank you.
All right, good luck to you on that one. And then does she have any prior drunk driving, counsel?
No, Judge.
I'll give you a $1,000 personal bond on the other case on the OWI and suspend. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. Do you understand all of that?
Yes, Your Honor.
Judge, there is an offer on the driving law license.
It just says adjourn for discovery.
On the first one, that's for the OWI, but he did put in an offer on the B case, on the B file. I didn't know if the court wanted to just keep them together and take the pleas all at once.
He can't really do that. Split these up. I don't see any plea agreement in here. Let's just I'll give you $1,000 personal bond. She had a point allegedly of 0.0108, so I'll say no alcohol, ma'am. No alcohol or controlled substances. You cannot leave the state, cannot violate a law. You must appear in court as directed. What day do we want to give her?
June
Lisa?
25th at 9:45.
June 25th will be your court date, ma'am, at 9:45, okay? If you can't afford a lawyer, you're gonna have to fill out a petition for one, all right? Okay? Any questions?
Oh, yeah.
All right, so you can go down the hall. We'll give you a paper notice and you can pay your $100 on the civil infraction. Best of luck. Thank you.
Judge,
Yeah.
for Miss Allen, her end date was December 6th of 2023.
All right. People against Tangeray Danielle Allen, 22W831729.
Michael A. Carbon, P73824 on behalf of the defendant again, Your Honor.
Name?
Allen. Tangeray Allen.
Not sure what to say here, counsel.
Lisa, was the end date December of 2023 or 2022?
This shows 2023.
How when I got to prison April 26th of 2023. I've been in prison since April 26th of 2023. I was in Oakland County prior to coming to prison. They sent me to prison.
I can
From
only
Oakland
look,
County.
okay, I can
And
only
that
look
was-
at MDOC where you're at now, and it shows December.
That's when I came back from a
Ma'am,
writ.
ma'am. Don't start arguing with her. She's just pulling up information. She doesn't deserve your wrath.
No, I'm trying to explain to her.
Ma'am. All she said was that's when it shows that you went in December of 23. She doesn't have other information.
Okay.
Okay? So don't get on her tail. I mean, my God, what did she do wrong? You sound like you're
No, can I?
angry, and she
No,
didn't.
I'm trying to explain that I went on a writ back in September.
You already
Back to Oakland County.
this. You told me this. You told us both this. You told all three of us this 5 minutes ago. We know what you're saying. She's only telling you what the records show. That's all.
Okay.
I mean, I don't know what you want me to do here, counsel. Do you want me to adjourn it? Do you want me to, you tell me.
Well, Your Honor, I mean, we've got her on today with MDOC. Can we just have her talk to the the Woodhaven prosecutor? See if there's a potential resolution. I mean, she's not due to be released for 6 months.
You guys can do that. I thought you already did, no?
No.
Okay, well, why don't you go talk to the prosecutor for her? I'm gonna enter a not guilty plea for her, and you can see what you can resolve. Is that what you want to do?
Sure. I've got quite a few other arraignments at the moment, so it's gonna be a minute.
I thought we were doing time served for proof of if I had proof of
Hang on, Miss
incarceration.
Allen, just let me handle this, please.
I can't let her go in and talk to him though, right? I mean, she wants a lawyer. So, are we getting backed up, John? You know?
Mr. Crawford has quite a few, and then apparently Mr. Kramer's got quite a few arraignments. I've been giving Mr. Gates
Quite a few.
I've been giving Mr. Gates some.
Judge, she also has a pending felony with Hesson, so I can just adjourn it if you want to make it easier.
Yeah, let's do that. We'll adjourn this to when, Lisa?
June 25th at 10.
June 25th at 10. Make sure you give her a lawyer. Ma'am, you cannot leave the state without the consent of the court or violate any law. I mean, I get what you're saying, but I still have to tell you this. You must appear in court as directed. You're not to go near 23555 Allen Road in Woodhaven or any other Target store. Do you understand all of that, ma'am?
I do, yes.
All right, so we'll adjourn this. You can try to get proof of incarceration on the other if you want, and we'll go from there. Okay?
All right, thank you.
Good luck. We'll see you on that date. Thank you.
All right, I don't think it's any secret here at the Courtroom Files that we are a live show, but we're also live-ish. I do have things that are happening, but I will pause them and cue them up just so they're ready to show in their entirety. But I wanted to show you this paused screen right here before I hit the play button. Tell me that Judge Stevens doesn't look like he's about to pronounce a blessing upon the crowd. The freeze frame was just perfect, so thought I'd show you that. Now let's hit the play button, and let's see if he is going to pronounce a blessing or perhaps a curse and put somebody away for a long time. Let's see.
Okay. Yeah, it's not on the docket. Okay, good. Okay, thank you. All right, we now call Richard Gill.
Yes, sir.
That's you, sir?
Yes, sir.
In 24 CR 1240, you were here with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke probation filed as of May 21st, 2025. In this case, are you familiar with it?
Yes, sir.
Are we ready to proceed?
Yeah,
Mr. Dusler on his behalf. Raise your right hand, sir. Do you solemnly swear or affirm any statements that you're going to be making during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Can we proceed in summary? Does he waive a formal reading of this?
Yes.
In summary, sir, this first amended motion to revoke probation states that on October 7th, 2024, in this criminal district court, that you were sentenced to 10 years in prison, and that was suspended and probated for 10 years for the state jail felony of unauthorized use of a motor vehicle. Is all of that true, sir?
Yes. Counts 1, 4, 8.
8 states that you committed the offense of failing to ID as a fugitive with intent to give false information on or about May 2nd, 2025 in Jefferson County, Texas, which is in violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state of the United States. Do you understand what this charges you with?
Yes, sir.
Is this true or untrue?
It's true.
Are you pleading true voluntarily, knowingly, intelligently, and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea is true to one or more violations of probation? That's all it takes to revoke your probation. Your probation can be now revoked, and you can be sentenced to no less than 2 nor more than 10 years in prison. Do you understand?
Yes, sir.
Knowing that, do you insist on pleading true today to this violation?
Yes.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is there any need to
No,
plead
sir.
anything else? All
No.
right. Stand by. So originally, you entered your plea and were sentenced. This was a state jail felony of unauthorized use of a motor vehicle. However, you pleaded true back last October in this court when we placed you on probation to 2 other state jail felonies of theft prior convictions in 2023. So thus, that's why this is called a state jail felony, but it was punished because of those prior convictions as though it were a third degree felony. You understand?
Yes.
Okay. So that's why you're facing no less than 2, no more than 10 years confinement in prison for this, even though we're calling it a state jail felony because of the 2 other prior felony convictions that were enhanced or raised the punishment level here. All right, there is no agreement.
Correct.
Go ahead, for the defense.
Well, Your Honor, he's asking the court to hold this matter in abeyance and continue on probation. This new offense occurred when he was stopped on suspicion of possession of drugs. He made a mistake by giving.
I've got it. I've got it. Yes, ma'am. Sorry.
He realizes that he made a mistake by giving false identifying information. Realized that was not a smart thing
Thank
to
you,
do
Mr. Fair.
at the time. But he feels like he can successfully complete his probation. We're not showing anything really, really bad right now. He is currently trying to rehabilitate himself from drug and alcohol use. It feels like with continued supervision from the probation department that he can successfully complete his probation. Is that correct, sir?
Yes, sir.
Is there anything else that I've not said that you want to add for the judge benefit?
Well, Your Honor, if it's, I would love to go to get some help.
Now?
If that's possible.
Well, have you ever been treated before for substance abuse?
Yes. There was a while back.
When?
So this, 2019.
I don't consider that all that long ago. Oh, well, but where was that? What was the treatment?
Oh, this was in Dallas, Texas, sir.
Dallas? How long were you in treatment?
For 90 days.
It looks like you have a real prolific criminal history that I stuck my neck out on and granted you probation for. How many misdemeanor and felony convictions do you have?
I don't know.
What does that say? That you don't even know how many convictions you have?
Well, convictions only have 2. I have 2 felony convictions.
You swear to God on that?
Yes, I only have 2 that I was arrested for, but no convictions.
I'm looking at 3 convictions here. Theft of property in Hardin County in 2017. You were placed on 4 years deferred probation for that on July 8th, 19, and another theft of property from 2018 in Hardin County, Texas. On that same date, you were placed on deferred probation in 2019 for both of those. Those were revoked in 2023, and you received 9 months state jail in each of those 2.
Yes.
Plus, this case, you were convicted of this and sentenced to 10 years in prison, and that was suspended, but it's a conviction. So you've got 3 convictions, including this one. What about your misdemeanors on what kind of, this was a unauthorized use, kind of a theft, a related theft. Do you have any other theft convictions or anything like that? Yes, you do. You got in 2012, you committed theft in Ellis County, Texas. You were placed on 2 years deferred or unadjudicated probation for that theft in 2014. And the next year it was revoked and you were sentenced to 60 days in jail for that. Now, do you remember?
Yes, sir.
And then a misdemeanor of assault causing bodily injury to family. That was in 2015. You were placed on 12 months deferred or unadjudicated probation in 2016 for that. It does not show that that was revoked. So you must have served that out properly. Then you got a failure to identify in Tarrant County. In 2015, you were sentenced to 7 days in jail. And let's go up to 2017 in Hardin County, 2 thefts of property. In February of 2017, in the next month, you pleaded guilty and were sentenced to 40 days in jail on each of those 2. You remember those now?
The 2 in Hardin County. The only ones I remember is the ones I went to state jail for. So.
Well, it's too bad you don't remember, but the computer remembers. And then we round out the field with failure to identify. In 2019, you were placed on 1 year probation, adjudicated probation. That was revoked and you were sentenced to 88 days in jail. That was out of Hardin County. Failure to identify, 30 days in jail in 2023. And resisting arrest in 2024, you get 44 days in jail. And those were here in Jefferson County, Texas. So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 convictions in courts of record, including 3 felonies. And here we are. What state say?
Your Honor, the state, based on the defendant's criminal history, he'd been given a chance before on probation. Honestly, he knew what he was supposed to do on this, and he didn't. He's got 3 new offenses while he's on probation, testing positive for cocaine. He's not reporting. Just about everything you can to violate his probation. The state believes the defendant should not be successful if continued on probation. We're asking for 6 years TDC.
Anything else?
No, sir, I believe. Memoir.
Did you, Mr. Gill, this is your life. What do you want to say? Anything else you want to add? You got to fix all of this, you know. You got to start. I mean, it's in the record. So every time you commit another offense, it's piled on by these others things. These others add to the weight, and the law says it does. That's why you have to make the right choices from here on anyway, but it's just going to get more severe for you. Was there any restitution on that?
No, Your Honor.
No. Go ahead. Anything else? Nothing?
Well, Your Honor, it all comes back to being addicted.
Yes, sir.
You know, so I can't blame nobody but myself. But you know, it's just being an addict is the hardest thing.
Yes, sir.
And I apologize to you, to my family, to everybody that I've hurt because of my addiction, but I apologize.
What do you intend to do about it, though?
So
we here in this case, we worked on with him on a substance abuse issue, didn't we?
So he was supposed to go to Franklin House, check us up every 30 days. Never went.
Okay. So we tried to help you on that, but at the end of the day, you've got to pull your own weight.
Yes.
You know, it's up to you to make the choice, and it's you to walk the walk.
Mm-hmm.
We can only open the door of opportunity. You've got to walk through it. which you didn't do.
Yes.
Okay, but this will pass. This isn't one of those cases that that whatever I sent you on, you're gonna be serving a long time. I wouldn't want to serve one day, but you'll get out. And then it's up to you to decide what direction you head in.
Yes.
And there are a lot of centers, placements that can help you, but it's got to be your choice. You made the bad choices that put you into this. You can just as easily make the right choices. It's climbing a mountain a little bit, but it's your choice.
Yes.
And you got free will. Fix it because you seem sincere about it.
Yes.
But you've got to just don't talk the talk. Walk the walk that it takes to do the right thing and get it done. Fix that. Fix that. At the end of the day, other people aren't going to be able to do it for you. Yes, we'll make it available. It's available, but you've got to do the effort, the heavy lifting, like all of us do when we make mistakes to fix them. Okay. I'm going to find that there is sufficient evidence supporting this first amended motion to revoke it by preponderance of the evidence or greater. As allegation 8 has been proven true, as the defendant is knowingly, voluntarily admitted, and to a violation of probation, failing to ID as a fugitive with intent to give false information. And that is enough to grant this motion to revoke probation. Thus, your probation is hereby revoked, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years, which is half of what you were sentenced to. How much credit does he have?
First branch, I'm giving about 90 days. Going back.
You're going to be given credit for all time you have served in accordance with this. We'll figure out what it is, but this is not one of those cases where you are looking at serving half time, but there will be some time that you're going to have to serve before you are released. And hopefully the prison has opportunities available inside for people with substance abuse. They're supposed to. I understand they say they do. Take advantage of them when you can. So good luck to you. That is all. And we need to thumbprint one final time. And Quinette Henson, please.
Okie dokie, friends. So Ashley, a little while ago in the chat, you said, I ask myself sometimes what I would get a felony in, but nothing comes to mind except for self-defense. Well, I've got good news for you. Nothing has to come to mind. Some of you are probably familiar, but there's a fairly famous book out there called 3 Felonies a Day. And it kind of diagrams how, especially at the federal level, there are so many laws and so much going on that the average American commits 3 felonies a day and does not even recognize the fact that they are doing it. So real quick before we sign off here, I just pulled up a couple of interesting ones. So these are examples of laws that you don't even know existed. So you probably, well, you might know the name, but there's a guy named Bobby Unser, the late Bobby Unser. He passed away a couple of years ago. He is a 3-time Indianapolis 500 winner. In 1997, he was convicted of a federal crime that carried a $5,000 fine and 6 months in prison because he abandoned his snowmobile during a blizzard in a federal wilderness area. So there's that. There's a construction worker, Christopher Lewis. He received a fine and a shoplifting charge at the federal level because he was at the VA hospital and he refilled his soda cup without paying for the refill. So that's a crime. If you write, I did not know this one. If you write, It was a felony? Yeah. So if you write a personal check for under $1, that is punishable by up to 6 months in federal prison. Michael, this one is specifically for you. It is a 3-month jail sentence on the federal level if you knowingly and publicly provide a false weather report. So bear all those things in mind, dear friend, dear friends, plural. It's crazy. One of the things that I actually want to add to the live show, and hopefully I'll get it up and running soon, is some daily segments where we cover some things that aren't just looking at court. And one of them that I want to do is crazy laws that are on the books. We have too many laws, and it sets all of us up for failure. And it's why I've said multiple times that all of us are only a choice or two away from finding ourselves in front of one of these judges, half of the time unknowingly. So it's just something to bear in mind. So yeah, oh wow, really? Oh dear, yeah. It's crazy. So far, I haven't knowingly provided a false report. Good on you, Michael, because I would hate to have to turn you in, my friend. Because, you know, I'm pretty sure I would be an accessory to it if I didn't. So it's a crazy world. All right, well, I hope you all had fun today. We certainly did. And again, thank you to all of the kindness out there. Barbara, for your super chat, for the gifted memberships, for everything. You guys are the best. So new members, congratulations, and you should join us tomorrow.
Wasn't it Lindsay or Ashley?
Ashley, Lindsay, yeah, they provided. Yeah, so the person talking to me, because I didn't say this, is Mrs. the Courtroom Files. She's been sitting in today. Anyways, you guys are great. But the new channel members, you can join us a half an hour before the live show tomorrow, so 9:30 Eastern, 6:30 Pacific, for our pre-show, where we have a lot of fun, so you should check that out. But for the rest of y'all, we'll see you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Go have yourselves a great Wednesday, and we'll see y'all again tomorrow. Take care. God bless.